Okay, good evening. So we'll start our lecture now. Okay. First of all, some housekeeping matter. Today is our eighth lesson. We'll cover the topic of legal profession. That's chapter 9. We'll skip ADL in the meantime. Because ADL is a very short topic. So we'll cover ADL in the last lesson. Then next lesson we'll cover chapter 10. That's legal aid. Following job. In the last lesson, that's the lesson after the national holiday. The lesson after the national day. We will have the last lesson. It will cover chapter 8. ADL. Because we only need say I think half a lesson to cover ADL. And then we'll do some final revision. Okay. So it's what we are going to do for today's lesson. Right. Now we go to chapter 8. Legal profession. Chapter 9. So it's legal profession. Right? First of all, so this is the outline for this lesson. For legal profession, of course, we have lawyer. But of course, there are so many terms for different types of lawyer. For example, solicitor, barrister, counsel, and also attesting officer. So many, right? I will go through different aspects of the legal profession one by one. First of all, admission. It means how a person can be admitted as a lawyer of Hong Kong. Okay? And also category of legal work. So we try to classify the legal work into different category. Quite crucial matter is about the right of audience. A right of audience means the right to be heard in the court, the right to speak for the client in the court. It's of course it's a very controversial issue, especially shortly after say 1997. There was very serious conflict between the two different branches of the legal profession. That's solicitor and also barrister. Of course, nowadays I think this issue has already been settled because now we have the solicitor advocate. For those people who want to do advocacy work, so they can apply to be solicitor advocate. So it's a quite reasonable arrangement. The arrangement is quite, I think it's quite good to both branches of the legal profession. I think most people are quite happy with the arrangement. And then fusion. Fusion means that the merger, merger of the two branches. Because in the world, so only UK and Hong Kong are still practicing this kind of system. So you look at in other countries like US, Australia, I think New Zealand, Canada. They don't have any solicitor. But only Hong Kong and UK are still using, still having the two separate branch of the legal profession. So for the term solicitor, some people may not know what a solicitor means. If I tell other people that I'm a solicitor, people in other countries may not quite understand what it means. Professional misconduct. From time to time, the lawyer will do something wrong. It may not. Sometimes it may. Some serious misconduct may amount to criminal offense. For example, theft, deception. There are even say criminal offense, right? But some wrong may not be so serious as to amount to criminal offense. They are only regarded as misconduct. So as we have mentioned before, in Hong Kong, all the professional body, they are regulating themselves. We are not regulated by the government. We are regulated by ourselves. There's the Bar Association and also the Law Society. So there will be say disciplinary hearing, disciplinary tribunal. So the lawyer he will be trial by there will be hearing by a panel of a very experienced solicitor. So legal ethics, so some ethical rules and also some rules relating to the legal profession, like accounts rule or some other rule. And so disciplinary proceeding. So for those people who have committed, say, professional misconduct, there will be disciplinary proceeding against them. If they are found, at the end of the day, they may be subject to some punishment. The last one is also a crucial topic. It's called immunity. Immunity means exemption. When I say someone is immune, of course, so nowadays we also talk about immunity. We want to be immune from the virus. So for some people will have the privilege, like the judge or barrister, they may have the immunity. So we are talking about this issue. I will discuss this issue. So the legal position is a little bit unclear in Hong Kong. Okay, the first one is about access to the law. Access to law, it does not mean access to law book. In fact, everyone can have access to the law book, to legal information. Whereas whenever you have the internet, you can always have access to the legislation or case law. But for the term access to the law, it means access to legal service. Okay? So it's a fundamental human right. It means being able to find a person who can help to solve a specific problem by providing legal services. Okay, especially urgent is a criminal case. For example, if someone is arrested, usually we want the lawyer to come as quickly as possible. So is the the meaning of access to the law. Usually civil case may not be so urgent. For example, you want to sue someone, usually you are not so eager to do the job immediately. Usually you can wait for a certain time before you decide to sue someone. But for criminal case, especially for arrest, usually the suspect would like to get the legal service as quickly as possible. For admission as a Hong Kong lawyer, so briefly, we can say that. For all of you, after you have finished your DLS, you may proceed to either LB, CPE. If you have, if you already have a bachelor degree, you can proceed directly to JDLB or CPE. All of them are recognized legal qualification leading to the PCL program in Hong Kong. After you have finished the LB, CPE, or JD, you can proceed to PCLL. PCLL is unique in the world. There's no other place using the same system, including UK. So if you study law in UK, usually you have to sit for the examination, offered by either the Law Society or the Bar Association. But in Hong Kong, we don't have this kind of examination. You don't have to sit for a public examination. You only have to finish the PCL program. I think the historical background is that when we have the first law school in Hong Kong, I don't know the year or the law school was established in Hong Kong. Of course, everyone knows that the first law school was the Law School of Hong Kong U. I don't know when it was established. Do you know the year when the Law School of Hong Kong U was established? It should be 1969. 1969. So the first batch of graduate at that time, it should be 3-year program, LB program. So the first batch of graduate should be so in 1972. So can you name some of the graduate of Hong Kong U Law School? Some of them are very famous. Like Martin Lee is not a graduate of Hong Kong U Law School. He studied law in England. Because I think he was called to the bar in 1966 or 67. Okay? So the first batch for those people, I think Alan Leung is not the first batch. So Wani Tong, Tong Gawa, okay, so Audrey Yu, they are very famous people. After they have finished the LB program, they have to go to England to study for the professional examination. At that time, we did not have the PCL, so they have to go to London to study, to sit for the bar examination. So in fact, Wani Tong was first in position in the bar examination. So he is. I think we should be proud of him. So no matter whether you agree with his political standpoint, but this is very brilliant. Because as a Chinese, English is not our mother tongue. But still we can manage to get the the first place in the examination. 當然係考第一嘅佢so when he compete with other English lawyer or English law student, so he could perform so well in the examination. So also Audrey Yu, okay, but later on also no need to go to England. So we could finish our legal study in Hong Kong because we have the PCL. So because for the so early stage, so Hong Kong only have just one law school. So there may not be any need to have any examination because the pool is very small. Each year the class only have 50 students. You can imagine how small our class are. So we only have 50 students, 50 students every year. Right? It was a very small number. Right? So there was no need to have any public examination. So we designed the PCL program. So as long as you can finish the LB PCL program, you could become a trainee solicitor. There's either in the law firm or in the chamber of the barrister. So of course, we still did not change the system. So we still use the PCL. So instead of professional examination for England, so because England has so many law schools, I think they have around 100 law schools. This is the reason why they have to use a public examination, a professional examination, just like the accountant. They have to sit for their professional examination. So for after a student have finished the PCL, he could choose either to be a trainee solicitor or pupil. So he could choose either to be a solicitor or barrister. If he want to be a solicitor, he have to finish a 2-year training as a trainee solicitor. This is a very funny term because I don't know. So the formal term of trainee solicitor. Trainee solicitor is very easy to understand. You tell other people that you are a trainee solicitor. Most people could understand what it means. In Chinese, 見習律師. Okay, so it's very easy. So it's very easy to understand term. I don't know the formal name of trainee solicitor. In the past, in the 80s, they were not called trainee solicitor. So you know the term. Anyone know the term? Anyone know the term of trainee solicitor in, say, no? It was called. It was called article clerk. Sorry. Some mistake. It was a very funny term. So when you told other people that you are an article clerk, some people think that you are only a law clerk. In fact, the formal name was article clerk. Why is called article clerk. Because when we join the law firm, we have to sign a document called article. Article is a document between the article clerk and the law firm. So some kind of contract. So they call it article. Okay. So it's the reason why we are called article clerk, because we are under the article. Sometimes it's quite embarrassing. So because we do not have the formal name of Chinese solicitor or 見習律師. So we do not. At that time we did not even have a formal title. So it's the reason. Sometimes it was quite difficult for us to tell other people what we are doing. Also, people there for the British people, they don't want to exaggerate the position. Sometimes they only use the term clerk. But don't think that he is for example clerk to the council. In England, so many city council, the head is only called the clerk to the council. 嗰個市議會嘅秘書長嚟嘅，其實嘅我Legislature is also the same. Legislative council. So in the past, he was that person was called clerk to the legislative council or clerk to the executive council. In fact, he or she was a very senior person, but the title was only clerk to the council. And also sometimes, for example, the head of the estate office is called estate officer. Okay? The head of the estate office of the Hong Kong U. He managed all the building of Hong Kong U, but he's only called an estate officer. Okay? In many estate management company, an estate officer is only a very junior person. Okay? But in Hong Kong U, he's already the head of the estate management department. He managed all the building of Hong Kong U, but he's only called an estate officer. It's the English style. So for the American, usually they will exaggerate the title. So it's the reason why you have so many vice president in American bank. So for training, solicitor we have a longer training period, which is 2 years. For a barrister, the training period is only 1 year. But of course, the format is very different. For training solicitor, usually they have salary. Sometimes in some firm they offer very high salary to the trainee solicitor. Okay? But for pupil, they have low salary. Okay? And also they are not the employee of the barrister. They are only the pupil. Pupil means student. So for the pupil, they will call those people to be pupil master. Okay? So if you join, you follow a barrister, he is your pupil master. These are the two possible routes to become a lawyer, either solicitor or barrister. Also, usually for the student, they have the choice. There's no special requirement. You want to be a barrister, there's no special requirement. Okay? It does not mean that you have to perform better than your classmate before you can become a barrister. Legally speaking, there's no special requirement. Okay? Of course, you have to judge. So whether you are suitable for court work or say the work of solicitor, whether which one is more suitable to you. There's no fine and strict rule. Okay? We can never say a barrister is superior than solicitor. Some solicitor could earn more money. Okay, so some solicitor they are more brilliant than some barrister. So these are only two different routes. And also there's nothing like promotion. So many years ago, many clients always think that. You have been a solicitor for a certain period of time, you can be promoted to be a barrister. There's no such thing. There's no such thing. So usually as a law student, you can always choose either becoming a solicitor or barrister. Even though after you have practiced for a certain period of time, you can still just jump to another branch. Of course, nowadays it will be more difficult. In the past, it was quite easy. It was quite easy. We have some example. For example, Paul 姐，謝偉俊 Paul, at the very beginning, he was called to the bar. He was a barrister. After he had practiced for several years, he turned to be a solicitor. Because as a barrister, so you have to do all the job by yourself. The major difference between the two branches is that if you are very successful, no matter how successful you are, you have to handle the work by yourself. Usually, you cannot delegate the job to other people. But as a solicitor, if you have very good connection, you have very good level, you can have a lot of business. You don't have to do the job by yourself. You can delegate to other people, including law clerk, legal sec, or other solicitor. Okay? So as long as you have a lot of business, you can survive, even though you know nothing about law. Okay? So for some people, they have very poor knowledge in law, but they can still make a lot of money. Why? Because they can simply, once they have the business, they can always delegate the job to other people. He can employ someone to do the job for him, or he can form a partnership. He can ask other partner to do the job. It's totally up to him. Okay? Just like a sales representative. So if you can have a lot of clients, if you have a lot of business, you don't need to do anything. Okay? But as a barrister, you can't do this. You cannot employ anyone to do the job for you. You can only employ a legal sec. Okay. No, of course, he can do some clerical job for you. But you cannot employ another barrister to do the job for you. So it's the reason why Paul would prefer to be solicitor, because he has a very good level. He's very famous. He can attract so many clients. Okay? So he better operate a law firm instead of being a barrister. Another example is Mediator, okay? So I think many years ago, he turned to be I think in the early 90s, he turned to be a solicitor. Okay, because as a solicitor, you can make use of your network. Okay, so if you have a lot of network, you better be a solicitor. You're good. Admission. So we have several aspects. First of all, they must be proper training. Now they are all the lawyers. Usually they have received very good legal training. So through the LB program and also PCL. And also they must be properly qualified. They have to satisfy all the requirements prescribed by the legal practitioner ordinance. So this ordinance applies to all the lawyers in Hong Kong. Also, now all practicing lawyers in Hong Kong must have either recognized Bachelor of Law degree or some other recognized law qualification, including the CPE or JD. Also, usually they have to complete and pass the postgraduate certificate in law. Of course, there may be some exceptions. For example, for foreign lawyer, they can obtain the OLQE, Overseas Lawyer Qualification Examination, and become a qualified lawyer in Hong Kong. And also, for lawyer, they have to serve the necessary period of training. For solicitor, it's 2 years. For barrister, it's only 1 year. So, in practice, we have more training. We have longer training than barrister. Okay, they only need 1 year of training, but we need 2 years of training. Usually, during the 2 years, so the solicitor will be assigned to different departments. Okay, for example, so the first 6 months for litigation, 6 months for conveyancing, 6 months for commercial, 6 months for some other thing like probate or some shipping or some other department. So these usually for solicitor, they have more all-rounded training. Because many law firms, they are more well organized, more established. There are so many departments in a law firm, especially for some city firm. But for barristers, sometimes the problem is that they are only individual. Okay? So they may be expert in litigation, but they are just an individual. Okay? So they cannot form partnership, they cannot employ other people. So they are only practicing on an individual basis. For category of legal work, so of course we can have different classification. We can classify the legal work into in different way. But a more traditional or conventional way of classification is that so we will divide them into say work relating to court work or not relating to court work. The first one is advice and assistance out of court. We call it non-contentious. It means that there's no dispute, low contention. Contention means dispute. If there's no dispute, usually, for example, drafting a will, drafting a contract, tenancy agreement, conveyancing. For those work, usually there will be we need the lawyer have to draft lots of legal documentation like tenancy agreement, etc. And so he will take instruction and draft the agreement according to the the instruction of the client, and then he will negotiate with the other party through the lawyer. They will amend the contract or amend the term and condition, etc., etc. And so the job. After both parties agree on the content, so he will arrange signing of the document. So it's the job of for non-contentious work. But the other one is representation in court. Representation means representing the client in the court. Okay, so we call it contentious. Another term is called advocacy. So advocacy is a legal term. Okay, so it means the art of debating in court. 法庭辯論技巧. Right. In fact, it's a subject in the PCL program. So if you want to be a lawyer, if you study in the PCL program, usually there's one of the subject, okay? Advocacy, just like debating, but it's debating in the court instead of just debating. So it's for the advocacy. So you have to follow a lot of rules. There are so many rules. So don't expect the lawyer are very eloquent. If you go to the court, usually the lawyer will speak quite slowly. Why? Because when he make mistake, he will be criticized by the judge. So he has to follow a lot of rules, and also when he's making the submission, he has to cite a lot of legal authority. So he cannot just use his common sense in debating. So the job is very different from debating. The classification is conventional. It does not extend to all types of work. Some work, so of course, is something very old style. Nowadays, we have a lot of work law may not be covered as contentious or non-contentious. Okay? And also, even for litigation, for the lawyer, they have to advise the client so at a certain stage. In Module 2, if you go to Module 2, so you'll find this civil litigation. You'll find there are so many stages of litigation. Okay? Before a case is heard in the court, both parties have to go through so many things before the case is heard in the court. Okay? So when someone decided to sue another party, usually it may take 1 to 2 years before the case can be set down for trial. And the next one is right of ordinance, 出庭發言權. It means the right to be heard in a court or tribunal. So in Hong Kong, litigant usually he has two choices. Either he can be a litigant in person. So sometimes it's called LIP, litigant in person. Sometimes it's called in person. Can you still recall the case of Yun Sek On? Mr. Yun, he was in person. In person means that he is not represented by any lawyer. Right? He just represents himself in legal proceeding. It's called litigant in person. So if you visit the website of the judiciary, you'll find a column called Resource Center for litigant in person. Because nowadays in Hong Kong, we have more and more litigant in person. So many people they want to take legal action, but they cannot afford the legal costs. So they are acting as litigant in person. You may recall that many years ago, there was a very wealthy people called a wealthy person called Yang Yaozhong. I think you may have heard of his name. Mr. Yang, he was very wealthy. In fact, so many industrial buildings was named after him. So from time to time, for example, in Kowloon Bay, you can see a industrial building called Yang Yaozhong 工業大廈. Okay? So in Hong Kong, so many buildings, industrial building named after him. So one time he also acted as a litigant in person. It does not mean that he did not have money. He was very wealthy. He had lots of money. He could afford to retain many lawyers. Okay? So when the newspaper interviewed him, so Mr. Yang, why you know a litigant in person? Why don't you say retain a lawyer to represent you? Mr. Yang said, I did not know. In fact, I could be a litigant in person in the past. I always thought that. So if I am involved in litigation, I have to retain a lawyer. Now I know I don't need to retain a lawyer. So no, I am debating for myself. I act like a lawyer. Okay, I feel so good. So he feels so satisfied because when he was debating in the court, he thought that he was a lawyer. 因為咁樣做，覺得可以做當咗自己係律師，好爽啊！佢。So he was very happy. He was so excited when he was debating in the court because maybe he liked that experience. So he thought he was a lawyer, and then he was very happy about that. So the reason may not be money. Some people, even though they have money, they still want to be litigating in person. Or he can, of course, most people will retain a lawyer to represent him. But he cannot find a friend who is not a lawyer to represent him. For example, if your friend has a lot of legal knowledge, usually you are not allowed to ask him to represent you. Okay? I think in some special case, there may be the court may agree. For example, an old lady very poor, he may ask his son to represent him. But usually, so if you ask your friend to represent you, usually it's not allowed. But you may ask someone to prepare the legal document for you. Right? So for preparing the legal document, I think it's still allowed. And also many law clerks, they will do this job. Sometimes they will accept the job. They will contact some person. They will offer to draw the legal document for them. And also they will charge some money. It's something quite common in Hong Kong. But the law clerk, of course, he cannot appear in the court. So for wage awarding, so we have two different branches of law, solicitor and also barrister. For solicitor, we just focus on ordinary solicitor. Ordinary solicitor means that those solicitors who are not solicitor advocate. Later on, I will come across a term called solicitor advocate. Okay? So they are solicitor with special qualification. Okay? They can enjoy more wage awarding. But no, we just look at ordinary solicitor. So for ordinary solicitor, usually they only have wage awardings up to the district court. Of course, for tribunal, people that only say the land tribunal, 土地審裁處, only the land tribunal allow legal representation. For other tribunal, like the small claim tribunal, labor tribunal, they do not allow any legal representation. So it means that the party cannot retain a solicitor or barrister to represent them. So for solicitor, in fact, they can also do advocacy work. So he has wage awarding in magistrate court and also district court. The reason why solicitor always give the impression to other people that they will not attend any court work. One of the reasons is that so for solicitor usually so they do not bother to do any court work. Court work, in fact, is quite time consuming. Imagine if you have a court case in Fanling Magistrate, you live in Robinson Road, so you have to wake up so early and then you go to Fanling, so you do a lot of traveling. Okay, so it's very time consuming. You have to spend so much time for a court case. So it's the reason why especially in the 70 and 80, for solicitor, they could earn a lot of money from conveyancing work. Okay? So it's the reason why they do not bother. They do not bother to do any court work. Usually they will give the court work to the junior counsel. For barrister who had just graduated from the law school, usually they are willing to take up whatsoever case, for example, a case in Fanning, a case in Kwun Tong, a case in Tuen Mun. Okay? But of course, if they are more experienced, if they are say usually they will handle more complicated work instead of some very small case. But for solicitor, they will prefer to stay in the office because they can save a lot of traveling time, and also life will be much easier. And then when they are more senior, usually for solicitor, they will become a boss in the law firm. They have their own firm, or they will form partnership. Usually, what will they do? They will delegate the job to the law clerk. They will delegate or convincing. Many solicitors, they do not handle the work, so they just delegate the work to the law clerk and ask the law clerk to do everything. So for the solicitor, he just sign his name. So the only job a solicitor will do is to sign on the necessary document. 咁最後就係做嘅就係簽名嘅。Of course, he has to supervise the law clerk, and also he has to manage the law firm, and also he has to say entertain the client, check a lot of business for the law firm. It's what a solicitor board, is what a solicitor firm partner will do. This is also the reason for solicitor. So if they are more senior, they're less familiar with the law. I can tell you. So in the law firm, the person who is most familiar with the law is the fresh graduate. For those partners, those people who are very say experienced, usually they are not so familiar with law, especially the legal law. So for barrister, so they have unlimited wage of ordinance. It means that they can say have the wage of ordinance up to the court of final appeal. So if you just look at this chart, this slide, of course, everyone will say, "Oh, barrister should be more superior. He has much better wage of ordinance." So why do you want to be a solicitor? What's the reason? So on the face of it, so barrister, of course, is much more superior than solicitor. If it is the case, no one would like to be solicitor. Why some people, or why so many people still want to be solicitor? What's the reason? Are you ever saying? More income, okay? Of course, there may be give and take. So don't think that's one-sided. If it's one-sided, if lawyer can only do litigation, if barrister have unlimited wage of ordinance, so no one will want to be a solicitor. Okay? The reason is that solicitor have a lot of privilege. For example, conveyancing. So no succession, probate, so many work can only be done by solicitor. Okay? So for the solicitor, so they only use the service of barrister when they have some difficulty, some difficult law point, they can resolve. Okay? Usually, for most of the work, they are done by the solicitor. Like you want to prepare a will, 遺囑, okay, or probate, 遺產承辦, okay, or conveyancing, buying a flat, selling a flat, buying a shop, tenancy matter. Most of the work are done by solicitor. Okay? The barrister simply cannot participate in those business. Even for litigation. So especially for litigation work in the lower court, the solicitor can choose whether the work is good or not. If the work is not so good, he will pass to the barrister. Okay? If the work is very easy or very good, he can choose to take up the job. Okay? So for the solicitor, they are in a much better position than the barrister. And also for a client, even though the case is in court of first instance, you need a barrister, but you also need a solicitor. You cannot instruct the barrister directly, as in Hong Kong is not allowed. usually the client has to go through a solicitor firm before he can retain a barrister. Right? Later on, I will talk about this case. It's called, say, fusion of the two different branches of the legal profession. Voice of Ordinance. So before 1997, when the conveyancing market was very good, a solicitor did not bother to do any court work. Okay, so they did not have any dispute with the barrister. I think only a very few solicitor would have interest in court work before 1997. Okay, so can you guess how much money those solicitors could earn in the 80s? Some people could earn 200,000 every month. They could earn as much as 200,000 every month in the 80s. So the price of a flat in Telford Garden, in the 1980, the price was only 200,000. But a solicitor could earn 200,000 per month. It means that just 1 month's income, he could buy a flat. In Telford Garden, 1個月嘅幾入息已經可以買一層德福花園你嘅身體所以 it's something very wonderful. So there was after 1997, because the market was so bad, especially called conveyancing. There was a slump in the property market. For solicitor, they simply could not earn the living by conveyancing work. And also the competition was very keen, so solicitor had to cut the price. So after 1997, they could only charge several thousand for a conveyancing work. But before 1997, we call that in the 80s, why they earn so much money? Usually they charge 20,000 or 30,000 for a case in conveyancing in the 80s. Okay? So you see, it was a very big sum of money. Many flats were only, so the price was only 500,000, but the solicitor firm will charge you 20,000. So it was a very high proportion, high percentage. Okay? But in the after 1997, because of the competition between law firms, so many law firms, they could only charge several thousand for a case. So for the barrister, they argue that they are expert in advocacy. They should continue to enjoy monopoly. So by then, so that the standard of advocacy can be maintained. So the solicitor argue that they should be entitled to the right of audience in High Court. Clients should have choice not to retain a barrister. And also they have a lot of argument like, you can save the cost. You don't need 2 lawyers, you only need 1 lawyer. So considerable debate. There was considerable debate between the two branches of the legal profession on the issue of widening wage of audience for solicitor. Fusion. Fusion is never an issue. I think as long as I recall, no one strongly advocate a fusion of the two different branches of the legal profession. Even nowadays, no one advocate a fusion of the two different branches. Right? So usually we only come across this issue in law book, but in practice, in Hong Kong, so I cannot see anyone who like to merge the two branches of the legal profession. So fusion is something quite unlikely in the foreseeable future. And now we have the solicitor advocate. So in the year of 2004, so we have the final report of the Working Party on solicitor wage of audience. So at the end of the day, so the solicitor wage of audience was extended in 2010 by the Legal Practitioner Amendment Ordinance. It's mainly for solicitor with 5 years post-qualification experience. It means that the minimum requirement is 5 years PQE, post-qualification experience, and also sufficient litigation experience, preferably actual advocacy. Actual advocacy means the solicitor appear in the court directly instead of just retaining a lawyer. So for many litigation lawyers, sometimes they do not appear in the court. 唔係真係出庭，佢真係做文書嘅。So many litigation lawyers, so no, they just handle the paperwork. He does not appear in the court for the client. He just retained the barrister to appear in the court. So he only handle the say document. So no, we have in module 2. When you study civil procedure, you find a lot of document. For example, statement of claim, writ, defense, reply, etc. These are the document for court work. So if a solicitor want to be solicitor advocate, he can apply for right of ordinance in the High Court in any of the following category, either civil or criminal or civil and criminal. People for lawyer, do you think is usual for a lawyer to handle both civil case and criminal case? Do you think lawyer or barrister, they will specialize in civil action or criminal action, or would they handle both of them? Do you think lawyer will handle both civil case or criminal case, or either one? Both. Legally speaking, theoretically, so a lawyer, as long as he's qualified, he can handle civil case and criminal case. But in practice, it's not too common. Why? Because for civil case lawyer or criminal lawyer, usually they are very special. They are very different. For civil lawyer, usually they are very calculating. Therefore, if you are doing civil work, the main concern is money. Okay? So you will be very calculating every time. You have to calculate the amount of money, the amount of compensation, so for each item, etc. Okay, you have to debate, you have to argue with other people in terms of the amount of that item. Don't think that we are only using a lump sum. Okay, so at the end of the day, the plaintiff could, if he win the case, he can get a certain amount of money. But the total amount, the total sum is broken down into so many items. Okay, just like the case when you run a shop. So of course, so you earn profit or you lose money. So there's a total amount. But the total amount depends on so many different items. Okay, so if you are a businessman, what is your mentality? Your mentality usually used to be quite quite calculating. Some people may be more generous. Some people are very mean. Okay, so he will try to minimize the expenditure. He will try to maximize his income. So for businessmen, we are talking about money. Okay? For civil lawyer, it's also the same. He will have the same mentality. Once he has practiced, when he has handled many civil litigation, he will become very calculating, very money-minded. Okay? How about criminal? So usually for criminal lawyer, he will have a lot of association with criminal. He also behave as a criminal. Okay, so especially, so what's the biggest source of work? What is the biggest source of work? If you are a junior criminal lawyer, usually you will be more familiar with people of trial society because they are the biggest source of income, biggest source of business. Okay, so for ordinary people, they seldom commit any criminal offense, right? Who will more likely who will commit criminal offense more likely? Usually they are those trial society members. So you want to have more job, you have to get more familiar with those people. Okay, so it's also the reason. So your mentality, your behavior will be a little bit different. So it's not too common for a lawyer to be specializing in both civil and criminal proceeding. Usually they have the specialization. So for people who are specializing in civil cases, he seldom do any criminal cases except some very petty criminal case. For those lawyers who are specializing in criminal cases, usually he will not handle any civil case. If the application is approved, the higher wage assessment board will notify the law society, and the law society will issue the successful applicant with a higher wage of ordinance certificate. Once he have obtained the certificate, he can practice as a solicitor advocate. So accordingly, the Legal Practitioner Ordinance 2010 came into effect in June 2012. The Code of Conduct for Solicitor Advocate has also been promulgated. Solicitor is now able to apply for accreditation to exercise higher wage of ordinance as Solicitor Advocate. We already have 75 as of August 2020. So we already have 25 Solicitor Advocate. Later on, I will show you the list of those people. Some may be more famous. There must be at least one solicitor advocate you should be quite familiar with. So for the list, you can go to this website. The list is in the website of the Law Society. Okay? All the solicitor advocate, they are member of the Law Society. So the total number is 75. Okay? I think one of the most famous one is Mr. Eric Zhang, Zhang Daming. Okay? He's also the principal lecturer of in the Faculty of Law of Hong Kong U. So in fact, before he joined, say the Hong Kong U as a law professor or law lecturer, he was working in JSM, Johnson Stock and Master, as partner. He was specializing in litigation. Okay. So now he still conducts some litigation sometimes. So despite the fact that he's a full-time lecturer of Hong Kong U. I think he should be quite famous. I think most people have heard of his name. And also, we have to examine the two different branches of the legal profession. For barrister, they are specialists in advocacy and also legal advice. So usually, the major work, is of course is court work. And sometimes they will also prepare some legal document relating to litigation. For example, writ, defense, reply, etc. Legally speaking, those documents can be prepared by solicitor. There's no need, legally speaking, there's no need to retain a barrister to prepare those documents. But usually they are more experienced. They are more skillful, more experienced. So many law firms, they will also ask a retainer barrister to prepare those documents. Okay? Preparing documents may not be so profitable. So usually they cannot charge too much, but it's more comfortable work. Because usually you don't have to, so the schedule will not be too tight. Also, many barristers will prefer, will welcome this kind of job. Because say it's you can do a job in the evening or any time you like. But for court work, you have to observe the time. The child is say early morning, in the morning. So you have to go to court to do the work. But for documentation, the document is more flexible. You can do the job anytime convenient to you. And also advice on the law in conference with solicitor and client and full written opinion. So do you know the hourly rate for conference? Do you know a famous barrister how much he will charge for conference? It may be $10,000 or even more. So very profitable for those who are famous. They charge a lot of money for attending the conference. It's $10,000 per hour. I mean, can you do you know those barrister? This lady, the pink lady. Do you know the name of the pink lady? This lady is called Priscilla Lang Mei Fan. Okay. This gentleman. Mr. Kwok Wing Hung. This one. EY Elvin Young. This Helen Leung. This one is Martini. Okay. All of them are the reason why they are more famous is because they have been or they are they are legislative council. Okay. So it's the reason why they are more famous. So for barrister, for a lot politicians usually they may not be so famous. Right. It's very funny. I think I don't know. Now we go to solicitor. Okay. So solicitor they tend to do more of the paperwork. Property transfer, lease agreement, divorce arrangement, contract, listing of share. Usually it's called IPO. Initial public offering. Also do the same kind of work as barrister for doing. Also advise on the law. I represent the client in the lower court and also in negotiation with other parties. Some people will call the solicitor to be family doctor. So they use an analogy. So solicitor, they are generalist, GP, general practitioner. Okay. So in case they cannot solve the problem, they don't have the expertise. They will refer the case to the barrister. Doctor is also the same. So we have family doctor, general practitioner, GP, right? So they will handle all the medical case. But in case of something complicated, they will refer the patient to a specialist. Okay? 專科. Okay? So it's more or less the same. But not exactly the same. Because for solicitor, sometimes they will handle very complicated case. And they will never refer the work to barrister. For example, IPO. So no, usually IPO will be handled by solicitor firm. They will never refer the case to the barrister. Okay, do you know those gentlemen? So this one, James Toh, Toh Gan San. This one, Jonas Ho, Ho Guan Yu. This one, Paul Jie, Jie Wei Jun. This one. Do you know this guy, this gentleman? Zhou Hauding, Mr. Chow, Mr. Chow. So far as members of the public are concerned, solicitors are usually the only kind of lawyer whose services they need. For most of the kind, usually when they have legal problem, they will approach the solicitor first. Barrister will normally be decided only if a particularly complicated legal issue is involved, or if the case go to the high court or above. Barrister may only be retained full as solicitor. So it means that the solicitor, the client, he cannot approach the barrister directly. He have to go through a solicitor. Okay. You want to retain Alan Leung, you want to retain, say, Elvin Young. You have to go through a law firm. And then we go to the topic of fusion. Fusion is the meaning is very simple. It means to merge the two different branches together. Because Hong Kong is still using the old system. I think this system is not used in most of the country in the world. For example, Japan or say Korea, no matter whether it's common law or civil law. I think civil law jurisdiction. So I think no country will use this system. Only common law will use, but still, even for common law jurisdiction, only UK and Hong Kong still use this system. Fusion means a unified legal profession. No more difference between lawyers. Okay? Of course, many clients will complain. Why do I have to retain two lawyers? Okay? Why I'm not allowed to just retain one lawyer? Okay? The lawyer will handle all the work. Why do I have to retain another lawyer? Of course, most people think that it will be more expensive if you have to retain two lawyers instead of just one lawyer. To compare the two different systems, so we can say summarize the advantages of fusion. One of the advantages is that it may reduce costs because only one lawyer need to be instructed. And also it may be more efficient. In particular, it reduces or eliminates duplication of work. Nowadays, if you want the barrister to do something, you have to send a letter to the solicitor. The solicitor will pass your request to the barrister. Sometimes he's just copying the point or the instruction of the client. Especially when sometimes the client supplies some information to the solicitor, and solicitor just copy the information to the barrister. So we can call it duplication of work. The solicitor he just duplicate the job. In fact, the job may not be too meaningful. And also it enhances the relationship between lawyer and client. For the client, they can contact the barrister directly. Under the current practice, the client is not allowed to contact the barrister directly. If you want to give an instruction here, you can only give the instruction to the solicitor and ask the solicitor to pass his instruction to the barrister. For information, it's also the same. If he can produce some evidence, he can only pass the evidence to the solicitor and ask the solicitor to pass the information to the barrister. Even in the court, it's also the same. So usually the client he cannot talk to the barrister directly. Or at least there must be a representative of the law firm. In all the conference, either the solicitor or a law clerk has to attend the conference. So even though they do not make too much contribution, but still there must be a representative from the law firm. The client cannot see the barrister directly. And also it encourages specialization thereby increasing the pool of experts. So if all the lawyer if all the lawyer can do litigation, but of course we can expect some lawyer who don't want to do litigation work, he may be specializing in some non-litigation work, for example, conveyancing or commercial cases, etc. If you allow all the lawyer to have rights of order, they will also do the specialization by themselves. Even though legally speaking, someone is allowed to appear in the court, he may not like it because he has no interest in litigation. He still prefer to be a commercial lawyer, drafting document for the client, etc., etc. Also, so it will expand the pool for appointment to the higher level of the judiciary. Because in our system, all the judges usually they have to be a lawyer, either as a solicitor or barrister. So if all the lawyers have rights of audience in the court, they will have more experience in litigation, more experience in advocacy, so that they can also be appointed as a judge. Nowadays, for the judiciary, they simply do not have enough judges. So I can tell you, it's the reality in Hong Kong. Of course, just I want to say something in the lesson because a little bit quite annoyed. Personally, I'm quite annoyed when so many people try to criticize the judiciary. The point is that, of course, I think that criticism is something allowed. So it's something very usual, but it's very sad. So many people, they simply do not have any legal knowledge. From time to time, they do not bother to read the judgment. Because for a judge, when he make a decision, he will write down the reason in the document called judgment, 判詞, okay, or reason for the decision. Okay, so if you want to criticize the judge, you better go through the judgment before you make the criticism. Okay, so many people they are not serious enough. They have low legal knowledge. Okay, they know nothing about law. And then they try to criticize, etc., etc. So they give a lot of nonsense statement. This is very, very ridiculous. So it's very harmful to the society. Okay, so I simply condemn those people. So for solicitor and barrister, they receive a similar education through the PCLR. So it means that we should not classify them, we should not divide them to be solicitor and barrister. They should have the same right, the same qualification, and also the same range of audience. And also, there are no inns of court. Many students do not know what's meant by inns of court. Inns, so you find this term in English dictionary. It means a small hotel. It was the old name for hotel, 旅館. Okay. But why it's related to law? It's very funny. One of the reasons, so by this name, you can also know the mentality of the British people. So once they have used the name, they do not bother to change the name. It's very funny. How can you call? In fact, it's a college of law. But how can you call a college of law to be inns of court? It's something very ridiculous. Okay, but for the British people, they don't like to change the name, even though the name is a little bit awkward, quite difficult to understand the meaning for people who know. For people who are not in the legal profession. So sometimes he may not quite understand what's meant by inns of court. In fact, inns of court is something quite unique in England. In England, so if you study law after the LB, you want to be a barrister, you have to go to London. Only London can provide courses for you to prepare yourself for the bar association. If you want to be a solicitor, you can go to any college of law. So for those college of law and inns of court, they are separated from the university. So it's very different from Hong Kong. Because in Hong Kong, LLB are provided by the university. PCLO are also provided by the university, either Hong Kong U, CU, or CTU. But in England, it's very different. The university only provide the Bachelor of Law degree. So for say the course, the preparation course for the Bar Association exam or the solicitor final, you have to go to the College of Law or Inns of Court. For solicitor, you have to go to one of the College of Law. They are not necessarily in London. Some may be in other places like Bristol. But say for Inns of Court, all of them are in London. It means that you must go to London. Okay, so you can find how they look like. So you go to Google. Okay, you type in the code, you can find those pictures. In fact, they're just college of law. They're just college of law. And also in England, so all the barristers belong to either one. So if you study in the say Inner Temple, so the name are also very funny. Okay, so the name, you go to Wikipedia, you can find the name of those 4 different inns. 2 are called inn. Lincoln's Inn, Gray's Inn, 2 are called temple, Inner Temple, and also Middle Temple. But they are not temple for religious activity. Don't confuse this term. They are only college of law. Because at the very beginning, they were very small inn, a very small hotel. For the law student, they have to study there, and also they have to live there. And also when you go there, you can find they have a very big canteen. Okay, so the dining hall, the temple or the inn, they are very close to the High Court of London. So if you are a barrister practicing in London during the lunchtime, you can go back to your own inn or temple for lunch. Of course, all the students can live there because they have very limited places. A lot they are. So in the past, all the students have to live in the temple or inn, okay, for 1 year. So after the course, he will sit for the examination. If he can pass the examination, he can become a barrister. For the inn, they are very different. They are not only College of Law for the preparation program. They also provide a lot of support. They will organize seminar or some other training or continuing training for the barrister. Okay. I think in Hong Kong, we don't have this kind of establishment or institution. We only have the Bar Association. Of course, the Bar Association will also provide support for the barrister. They also arrange some continuing education for barrister. But we don't have a very formal College of Law providing support for the barrister. So it's also one of the arguments. But we also have argument against fusion. Some people argue that it does not necessarily reduce cost. There's no evidence. Because if you want to put forward some argument, you have to do a lot of research. You have to do a lot of survey to collect a lot of data to justify your argument. You cannot just use your common sense. You cannot say, oh, no, if you have fusion, you only need one lawyer. Oh, the fee for one lawyer must be lower than the fee for the two lawyers. Okay? But some people argue that for, say, if you have two lawyers, so for the solicitor, they are specializing in paperwork. For the barrister, he's specializing in court work. The total cost may be less than the cost or the fee charged by just one lawyer, lower law. Okay? So you need very serious study or survey or some other research before you can give the conclusion. And also, there will be laws of specialist skill and advice. Because if we have merger, we have fusion, all the lawyers have to work in just one law firm. But nowadays, for barrister, you can serve so many law firms. Right? For example, if a barrister is a specialist in shipping law, he can serve all the law firm in Hong Kong. Any law firm can use his service. But if a barrister, if a lawyer is who is a specialist in shipping law, if we have fusion, he can only work for one law firm. Okay? He cannot work for other law firm. But now they are under our system. Okay? I say a barrister can work for all the law firm, any law firm in Hong Kong. And also there won't be any more the benefit of second opinion. Nowadays we have solicitor and also barrister. So you have the benefit of second opinion, just like a doctor. Many people, when they consult a doctor, the doctor give him the say advice, he will consult another doctor because he want to get the second opinion. Also, it will affect the relationship between the judges and the barrister. Because if there are so many lawyers who will do court work, the judge may not be able to memorize the name of those lawyer. Okay? Now they are. So the number of barristers is very small. So the judge can memorize all of them. The judge can assess the say performance. And also it will affect the reputation. But if the number is so big, how can the judge assess the performance? So of course, when a barrister wants to be a judge, he will be invited by the judiciary. How does the judiciary make the decision? As usually, it's based on the reputation of the barrister. Okay? Your barrister have good reputation, so he may be invited by the judiciary to become a judge. In Hong Kong, not so many people want to be judge. So my question is, do you think the life of a judge is good or not? Would you like to? Do you want to be a judge? I don't think that the life of a judge is very good. Sometimes the life is very boring. For the judge, he has to do his work alone. He cannot cooperate with other people. Maybe he has a good status, but now the situation may be very different. For the pro-government people, they always criticize the judge, okay? And also some anti-government camp, they also criticize the judge. The judge now is in the middle, so he's in having a very, very difficult position. And also he will lose a lot of freedom. So it's something very true. So if someone is a judge, he has to be very well behaved in social life, in private life, right? Of course, the salary, of course, when compared with some people, of course, some people will, oh no, it's very good. But if you compare the salary with some very successful lawyer, it may not be so attractive. Because many lawyer, very successful one, they can earn $10 million or even more a year. Okay, so if you are even for the chief justice, I think his salary is only around several million. So no, it will not be so good as a successful lawyer. Of course, the social status may be different. He can enjoy a lot of privilege. But the problem now there is under the pressure. Under the pressure of the public, under the pressure, or no, I don't know though. At least the judge are quite annoyed with the criticism by so many people, very irresponsible criticism. Michael, your answer, why choosing barrister if solicitor so much better? Do you mean why some people want to be barrister? Sometimes it all depends on your own caliber and also your character. Some people, they can never be a solicitor. Some people can never be a barrister. For example, you want to be a barrister, you must like debating. You don't like debating, don't be a barrister. Some people, they don't want to argue with other people. They are very, very peaceful people. They are, have very good temper. Some people are very, sociable. He may not like being a barrister. He would better be a solicitor. He would be a very successful solicitor because he's so sociable. He has very good network. He knows so many people. So if you are a solicitor, you can get a lot of business. Okay. So if you are a barrister, even though you know so many people, so it may not bring too much benefit to you. Because you have to do all the work by yourself. You cannot delegate the work to other people. Some barristers, they don't like paperwork. Because as a solicitor, you have to handle a lot of documents. So some people think that the job is very tedious. Okay? So they like advocacy, they like arguing with people in the court. So it all depends on your character. Okay, I think we have to take a break now. I think you are very tired, so we will take a break here. And so in the second part, also we will examine the question of professional misconduct, and also we will do some exercise. We will practice what we have learned. See you after the break. So please take a break now. Right, so we'll continue our lecture. So our students say he cannot find the PowerPoint. Please go to show. I think in your handbook or some, I think there's already some instruction. So if you please follow the instruction and go to show and find your lecture notes. Nowadays, so everything is by IT, so it's by full computer or website. We have to learn how to do this thing, and so even the teaching is online. I think at the very beginning, I was also quite annoyed with using the say the online teaching. So it's something quite inconvenient to me. But still, I'm now getting used to online teaching. Yeah, so we'll go to the remaining part of chapter 9. But before I start, I'd like you to go to the website of the Two Law Society. The first one is the Bar Association. So this one is the website of the Bar Association. Okay, bar is the is the short term for barrister. Sometimes it's very funny. So someone is called to the bar. When someone is called to the bar, it means that he became a barrister. So he's not going to the bar in China. For barrister, they have two different lists. The first one is called Senior Counsel (SC). In the past, it was called Queen's Counsel or even King's Counsel. Of course, you cannot find any King's Counsel nowadays because Queen Elizabeth II, he became the Queen in 1952. Okay? So for those King's Counsel, King's Counsel means that they got this title. Before the Queen, before before 1952. So I think so if someone could become a King's Counsel before 1952, I think it's quite unlikely he's still alive. For senior now, because after 1997, we could not use the term Queen's Counsel. We can only use senior counsel. But if you go to some foreign country like Canada, you can find someone using the title of Queen's Counsel or QC. For senior counsel, they are more successful barrister. Usually, so they must have some achievement or very good reputation, quite outstanding performance in litigation. In fact, they were invited by the title was given by the Department of Justice, I think. So it's nominated by the DOJ. In fact, you can find the most senior counsel in Hong Kong is Martin Lee. He's the most senior counsel. So in Hong Kong. I think he became a Queen's Counsel, I think in the 70s. Very famous before he became a legislative counsellor. I think he became a legislative counsellor in the year of 1984. 1984. Okay. 85 or something like that. He was the representative of the legal profession. He was called to the bar in 1966. So now he's the most senior counsel in Hong Kong. Some other are also quite famous. For example, Dennis Jiang, Zhang Jinlei, John Griffith, Ching Hong. Ching Hong should be the most successful criminal lawyer in Hong Kong. Ching Hong, okay. Edward Chang, Cheng King Sang. This lady, I think she should be the first female lawyer in Hong Kong. Female barrister in Hong Kong. Liang Bing大先. So when I was small boy, we do not have too many female lawyers. But now female is more than male. And so you have more women lawyer than male lawyer. Wang Li Wang, Wang Li Tong, and so Wang Li Tong. OGU. But now the most famous, most successful civil lawyer is Benjamin Yu. 民事最出嚟啊，呢個余未約海啊 ，so they are sister and brother 啊。So the only family, the Yu family, they are so proud of themselves, because they have two senior counsel in a family, okay? They are sister and brother, Orju Yu and also Benjamin Yu. But it's very funny, they have two different surnames. I mean, altogether, the numbers will be a little bit more than 100. So when I was a law student, the number of Queen's Counsel is only 10 something. I think 13 something. Now it's already more than 100. For the difference is that if you retain a senior counsel, you have to retain a junior counsel. It means that there must be at least two lawyers, two barristers. For junior counsel, the term is quite funny because some of the so-called junior counsel, in fact, they are already very old. No matter how old you are, even though you are at the age of 80, even though you have already been a barrister for 50 years, 60 years, you are still called a junior counsel. As long as you are not a senior counsel, you are a junior counsel. Okay? So of course, this gentleman, he was called to the bar in 1966. Okay? I think most likely he's already at the age of 80, right? Or at least 70 something. The second most senior junior counsel is a very famous one. Mediator Tam Wai-ju, okay? So he's the second most senior junior counsel in Hong Kong. And also for pupil, this is the list of pupil. And also for the office of the barrister is called chamber. Many people do not know the exact term for the office. Many people still call them law firm. In fact, it's not called law firm. It's called chamber. The term chamber is a very general term in English. It only means a small room. So we have chamber music,室樂. Right? And also the office of the judge is also called chamber. Sometimes the hearing is in chamber, 內庭聆訊. Okay? So some meeting or some hearing, they are not in the courtroom, they are in the chamber. Okay? For barrister, they cannot form partnership, they cannot be employed, they cannot employ someone, they cannot be employed. It means that they cannot form a company. For the chamber, it's only a collection. So only mean one or more barrister working together. Sometimes some chamber may only have one barrister. It's up to the barrister. It depends on the character of the barrister. Some barrister he may prefer to work alone. He does not want to work with other people. So the chamber may only have one barrister. It's something like that. But many chamber are very big. This one is very small. The chamber of Martin Lee. Why? Because he complained that he was always disturbed by the reporter. Sometimes the people from the TVB or ATV will come to his chamber to interview him. It may be disturbing to other chambermates. So it's the reason why he worked in a very small chamber. Some may be quite big. For example, this one, Liberty Chamber. So this one, you can find so many, right? You can find so many barristers. Usually we have a chamber head. So the SC usually is the chamber head. He's the head of the chamber. But he only have very limited authority. Because each barrister work on his own or her own. Okay. So he is not he cannot order anyone to do anything. Basically. So usually they will only join together to share the expenses, the rental, the salary for the receptionist, etc. So of course, if you join a chamber, so it depends on whether there's any vacancy. Some big chamber, reputable chamber, they have a quite high requirement. So it's not easy to go there. Okay, and also, if you join a chamber, you have to pay for the decoration. You have to pay a certain amount of money to share the decoration cost. Of course, there's some benefit. You join a very reputable chamber. From time to time, you can consult other barrister. For example, if you are a very junior barrister, so if you have any difficulty, you may, Mr. Granham is here, so you can consult him. You can go to his room and ask him some question. And also, if some barrister are very, he has a lot of work, sometimes he will pass the work to you. It's also the benefit of joining a successful chamber. Also, you can find many barrister. There are also arbitrator and also mediator. So it's the list of arbitrator who are also barrister, and also list of mediator who are also barrister. Some of course, so later on in chapter 8, I will learn more about arbitration and also mediation. For arbitrator, usually they are professional. They need not be lawyer. For arbitrator, they may be specialists in other areas, for example, engineer, architect, surveyor. But usually they are some kind of professional. But for mediator, the requirement is not too high. So many people can become a mediator, including family, housewife or even retiree, retired civil servant or teacher or manager, anyone. So you find the background of mediator are quite different from the background of arbitrator. So it has more variety. So many people can become mediator. Later on, you will know more about arbitration and also mediation. For arbitration, it's some kind of it's very similar to litigation. So it's someone called arbitrator. He acts as like a judge. He will make a ruling. So everyone know that. So for our current Secretary for Justice, okay. So 徐世正鄭日華he is a specialist in arbitrator. Okay, because he has both the legal and also engineering qualification. That is the reason why she can be a very successful arbitrator. So for mediation, it's different from arbitration. It's very different from litigation. The work of the mediator is to persuade the party to reach an agreement. He will not make any decision. His job is only to urge, to persuade, to convince the party to come into agreement. Sometimes he may be successful, sometimes he may be unsuccessful, but he will never make any ruling. He will never make any decision. His job is just like a middleman, just like an estate agent. He tries to make the deal, but of course, so from time to time, it's not successful. Okay? Oh, sorry. And then we go to the law society. So of course, the law society is a little bit different. Is the website of the law society. It's the main page. In the law society, you can find a lot of useful information. For example, the law list. Law list is the list of the solicitor. It's divided into so many lists. For example, member with practicing certificate. A lot of the many member. For some member they are practicing. Some member they are non-practicing. So what does it mean? Practicing, of course, Below those solicitor working in a law firm, usually they are practicing member. But we still have so many members who are not practicing, including say solicitor working in the government, teacher, or teaching in the university or other institution. Or in-house lawyer. And also one of the important category is called in-house lawyer. Nowadays we have many in-house lawyer. In the past, it was very uncommon. So I recall that when I was in-house lawyer. At the very beginning, people were very surprised when they knew that I was working in-house. But nowadays, it's very common. So many company, especially some big company, they will have a legal department. Usually, they may be 5 to 6 lawyers. It's not something exceptional. So, for example, MPLC or say Hong Kong Bank, usually they will have a quite big legal department. Associate member, usually they are law student, a student in the law school or the university. This one is the solicitor firm. For firm, they have different, you find the list. Some are very big, some are very small. For example, Allen & Overy is an international firm. It has so many offices. Okay? And also I can find they have so many lawyers. So they have so many offices. Even Paula is around 20. And also so many lawyers. So consultant. Usually they are they're more senior lawyer, but they are not partner. For partner, they have to they can share the profit. But for consultant, they cannot share the profit. Assistant solicitor or associate. For foreign firm, usually they use the term associate. For Chinese firm, we usually use the term assistant solicitor. This term is very bad because so many people think that they are not lawyer. In fact, they are qualified lawyer. Just because they are not partner, they are called assistant solicitor. In fact, I think it's not a very good term. 以為佢唔係律師以為係見習律師，其實唔係其實 in fact for assistant lawyer they are already qualified lawyer, they are already qualified solicitor. And also from time to time you find some foreign lawyer. What do they mean? So what's meant by foreign lawyer? A foreign lawyer means that they have the legal qualification in other jurisdictions. For example, so an English lawyer or US lawyer or Australian lawyer. They have the legal qualification, but only in other countries. Usually, so they are only allowed to practice the law of the jurisdiction. For example, Australian lawyer, they can only practice Australian law. But in practice, they also work for Hong Kong law, but they cannot sign the name on any document. Many law firms will employ those foreign lawyers. Some of them may be Hong Kong citizens. They just study law in Australia. They get the legal qualification in Australia. But when they return to Hong Kong, they cannot practice Hong Kong law. Usually they will work in the law firm. They will draw the document. So in fact, it's not too difficult for them to know Hong Kong law because the difference is not so big. Usually they will draft the document, they will do so many things, but they are not allowed to sign the name on the letter. They have to ask a Hong Kong lawyer to sign the name on those documents. So it's the reason why we have so many foreign lawyers in Hong Kong. So and also you can find different different types of lawyer. Some are called in-house lawyer. Okay, so they have the in-house lawyer committee. Also, arbitration service. Some solicitor are also arbitrator. Some solicitor are also mediator. High rights of audience is referring to the solicitor advocate. Also, we have some other lawyer. For example, say a law to the public, 公正律師。A law to the public usually they must have at least 10 years of post-qualification experience. Also, they have to go through some kind of examination before they can become a notary public. Usually, the function is to notarize some document to be used in foreign country. From time to time, so we will a solicitor can certify document. If the document is only used in Hong Kong, usually a solicitor is already in law. 即係佢簽一個副本for example, if you say no, if you apply for immigration, so no, if you want to emigrate to say Australia, the Australian government may require you to provide certified copy of your, for example, birth certificate, ID card, or some other document. Usually, you cannot give them the original. You can only give them the certified true copy. But usually, if the document is to be used in a foreign country, you need the service of the notary public. You have to ask a notary public to notarize the copy of the document. 咁佢簽喺副本就要一個公證律師，so it's called notary public. But in China, they do not use the system notary public. They do not recognize a notary public in Hong Kong. They use a title called China Appointed Attesting Officer. 中國司法部核認可公證人。So if the copy is used in mainland, so you have to use the service of a China Appointed Attesting Officer. For those people, usually they have to, at the very beginning, they were invited by the Chinese government to become those attesting officers. So nowadays, I think the number is very big. I don't know the exact number. Maybe 100 something. It should be 400 something. 449. The total number is 449. So they cannot earn too much money. In the past, they could earn a lot of money because at the very beginning, we only have 8. The number was 8. We only have 8, say, attesting officers, so they could earn a lot of money. But now, because the number is so big, altogether we have 449 attesting officers. Usually, they are also solicitors, right? But the recognition, the qualification must be given by the the Ministry of Justice in China. You can also find my name. So I'm a member of the Law Society, but I'm a non-practicing lawyer. I don't have the practicing cert. Because the practicing cert is quite expensive. You have to pay several $1,000. Right? Also, as a practicing lawyer, you have to take out insurance policy. 要買保險So we have the mandatory insurance policy for solicitor. So when the solicitor is negligent, he may be sued by the client, but the money will be paid by the insurance company. Just like a driver in Hong Kong. So all the driver, so they have to take out insurance policy because we have to protect so the possible victim in a car accident. I will go through it very quickly. This one is quite straightforward. So professional misconduct. So the purpose is to protect the public against professional misconduct. So altogether we have several category. Entry is something we have mentioned before. Liability under the general rule. General law means that for solicitor, when they provide service, they will have possible legal liability, then legal ethics, etc. The first liability under the general law. There will be breach of duty owed to client. So for the service provided by the lawyer, in fact, it's already a contract. So the solicitor firm and also the client, they already have a contractual relationship. And also if they owe duty to the client, if they breach the duty, they have to pay damages for breach of contract or for negligence. Also, for lawyer, they owe duty of care to the court, so they may be punished by the court. Also, for also because they are all the lawyer, the people the qualification is given by the court. All the lawyer in Hong Kong no matter whether he's a solicitor, barrister, the title, the qualification was given by the court instead of the law society or the bar association. These are two different things. The qualification will last forever. So once a person is admitted as the solicitor of the Supreme Court or the High Court of Hong Kong, the title will remain forever, will remain for the rest of his life. So he may choose not to be a member of the law society. It's not necessary. So for someone who's not a law society member, he can still have the title of solicitor of the Supreme Court of Hong Kong. So it's the reason why they owe duty to the court, because they are officer of the court. So for the contract between the solicitor firm and the client, it's called retainer. Retainer is the noun. Retain is the verb. R-E-T-A-I-N. Retain, right? Is the verb. The noun is retainer. Is the name for the contract between the solicitor firm and also the client. For the solicitor, they have the general duty account to the client. It means that they have to be responsible to the client to carry out the client's instruction, and also all the related matter by all proper means. Maintain confidentiality is very important, especially for the celebrity. Okay, so if the client is a movie star, if she's going to divorce with her husband, of course, so she may be quite worried that this case will be disclosed by the staff of the law firm. So the lawyer for the solicitor, he has to maintain confidentiality. And also he has to make sure that all the people in the law firm will remain the confidentiality, so to make it, to keep it confidential, to keep this matter, to keep this case confidential. Okay. On the contrary, sometimes you have to keep something confidential. Some matter you have to disclose. It's called disclosure, payload. Disclosure is a concept starting from 80. So I called it when I was a law student. I did not quite understand what's meant by disclosure. So it means that you have to tell the public some information. For example, your interest in the case, or interest in the company, how much money, how many property you have. For example, for electrical member and also senior government official, they have to disclose how many property they have. So this is the reason why we all know Mr. Zhang Ginzhong, he owns so many property in Hong Kong, because he has to disclose the details of those property to the public. Forms of the retainer, so usually it's reduced into writing. So of course, as a matter of urgency, it may be made only at the very beginning, but usually it will be reduced into writing. The usual format is a letter. It's a letter, right? So there will be the scope of the service and also the possible charge. So the burden is on the solicitor to prove that he has authority to act. So in some cases, especially in criminal case, the confirmation of instruction is very important. There must be written confirmation of instruction before a lawyer can participate in a criminal case. Because in a criminal case, sometimes it's more sensitive. So he has to contact the police to get some report or to some other thing. So it's very crucial. The lawyer will have the written confirmation of instruction. Decline a retainer. From time to time, the solicitor can decline a retainer. It means that he can refuse to work for a client. It's something allowed. People that for solicitor, they are allowed to refuse to serve a client. So there are some circumstances in which a solicitor should decline a retainer. For example, where the instruction will involve in the solicitor in illegality. Illegality means that he has to do something illegal, or breach of professional conduct rule. Sometimes the client may ask him to do something illegal or unprofessional, unethical. So result in a conflict of interest. A conflict of interest is more common nowadays. Later on I will show you some example of conflict of interest 利益衝突譬如for Chinese in the past we did not have the concept of conflict of interest. We did not know what's meant by conflict of interest. So it's a concept used by say British or American. They place very heavy emphasis on conflict of interest. So another solicitor is already acting for the client. So the solicitor has to make sure that there's no other solicitor acting for that client. Okay, a client cannot retain two solicitors to act for him at the same time. He can retain a very big law firm, but he cannot retain two law firms to act for him. Termination of retainer. So there's no provision. If there's no provision in the contract, the retainer is an entire contract. It means that so it will only come to an end when the case has been finished. For example, in litigation, so no, the retainer will only be terminated when the action is finished. A retainer may only be terminated if it's not unfair. From time to time, the solicitor can terminate the retainer, but he has to satisfy the requirement. It must not be unfair. Okay. For now, so if tomorrow is the court hearing, if the solicitor terminate the retainer today, it will be very unfair to the client because the client cannot find another solicitor to act for him within such a short time. And also, it's not done for an improper purpose. For example, if the solicitor say that if you do not give me more money, I will terminate. So the retainer also is something improper. And also, there must be some proper ground. Usually, the usual ground is that the solicitor simply has no manpower to handle the case. For example, if you have a very complicated case, you retain a small firm to do the job. They don't have the necessary manpower to do the job. So it's the reason why they should terminate the retainer. Also, a lawyer must comply with ethical standard, etc. So these are the different points. So you have to protect client's interests, avoiding conflict of interest, maintaining integrity, ensuring competence, and also avoid illegal behavior. We can see some of the example of conflict of interest. Sometimes the conflict is between clients. So it exists where the legal interests of one party in the matter are adverse to the legal interests of another party in the same matter. Okay? Just like the case, if you act for both the seller and buyer, there may be conflict of interest. Okay? Just like an estate agent. So in Hong Kong, an estate agent can act for both the buyer and seller, but it's not allowed in some other country, for example, Canada, or say no, it's not allowed. And it's the same estate agent cannot act for both because there will be conflict of interest. Because the seller always want to sell the property at a high price. The buyer always want to buy the property at a lower price. Okay? Also, the seller would like to say cover the defect of the house. The buyer would like to know all the defects of the house. So there must be conflict of interest between the buyer and the seller. So we go to page 151. These are some of the examples of possible conflict between the client. Page 151. Please go to page 151. Page 151, so you can find some of the example. For example, defending a co-accused. For example, in many cases, we have more than one defendant. Defendant 1, defendant 2, defendant 3. Usually we call them D1, D2, and D3. So why there will be conflict of interest between two defendants? The point is very simple. Usually the defendant will shift the burden to another defendant. Okay? For example, in a robbery case, in a fighting case, usually the defendant will shift the burden, will shift the responsibility to another defendant. 推卸責任 okay? For example, in a robbery case, one of the defendants will say he only played a very passive role. He was sleeping at the time. He did not know what happened. The other defendant will say that D1 is the ringleader. He planned all the case. He incited me to do the job. I was very unwilling to do, but he always pressed me to do the job. So usually the defendant will shift the burden to another defendant. Right? So if a lawyer acts for two defendants, he will be in a conflict of interest. He will be facing the conflict of interest between the two different kinds. Or representing a co-plaintiff in a tort case. Because there will also be conflict of interest acting for both the insured and the insured. Insured means the person who take out the insurance policy. 呢個投保人Okay, insurer means the insurance company. Usually, 受保人So there must be some conflict of interest. Especially in terms of the policy, there may be different interpretation. Of course, for the insurer, he want to get the money. For the insurance company, he want to minimize the compensation to the insured. Okay? So they are in a conflicting position. I think for the British people, they are more realistic. They know that there must be conflict of interest, so the only solution is to avoid conflict of interest. For Chinese, we always think that, we are very fair, so no, don't worry. So I will never make any unfair decision. We always think that we are very fair. We are not afraid of conflict of interest. So for Chinese, we do not have the concept of conflict of interest. The next one is conflict between lawyer and client. We go to page 152. This one is a conflict between, for example, purchasing an interest in the subject matter of the litigation. For example, if a lawyer is acting for the client in a litigation, so the case is about the title of a property. So if the lawyer want to buy that property, there will be conflict. Okay? Why? Because so the lawyer, if he can buy the property, he may have the incentive to say something bad about the property. He may tell the client, so the title defect is very serious. No one will buy your property. Right? You can never sell the property to anyone because there's a title defect. 個業權嘅缺陷so no one is willing to buy your property. So according to law, you can never do anything to remedial the situation. So if it's the case, the client may sell the property to him at a very low price. So the lawyer can make a lot of profit by buying the property at a very low price. So there will be conflict of interest. I think this one, we can skip this. I think this is not too useful. No, I think we should do an exercise before we end this lesson. I hope I can. This one is very good. So this exercise is very useful. So I hope you do this exercise. So it's activity 1 on page, say 153. Page 153. Please use 5 minutes time. So we have two situations. So you have to find out whether there's any ethical problem in the above cases. And if so, what it is. The first case, you are a convincing lawyer. So you are operating a law firm. So a friend of yours is a real estate agent. So you make an agreement with your friend. If your friend refer client to you, then you will charge them 30% less. It means that you give a 30% discount. And also you give 10% of your fee to your friend for introducing the client. So for this arrangement, it seems to be a win-win-win case. You can get more business, so the client can get the discount. Your friend will get the introduction fee or commission. all the three parties will benefit. But what is the ethical problem? Number two, you're a barrister and also director. The company is involved in a litigation. You agree to represent the company in a civil case at a small fee in order to save the company legal fee. What is the problem? Please write down your answer. We'll go through them one by one. So please use 5 minutes time to go through the question, and then we'll discuss the answer very briefly, and then we'll end the lecture. For the remaining part, we can leave it to next lesson. Because legal aid is not too long, so we can spend some time on the remaining part of this chapter. The ethical problem is not necessarily relating to the party. So for question one, you see that all of them, so all the three parties can benefit. Okay, but it may cause some ethical problem, for example, to the legal profession. You just confine your answer to the three party, the lawyer, the estate agent, and also the client. It seems that no one will suffer. Okay? Every party will get some benefit. Sometimes, so the arrangement may be beneficial to some people, but it may not be so good to the society or to the profession. Can you find out the ethical problem? Can you find anything wrong? On the face of it, so you cannot see anything wrong. So you have to be, say no, you have to think more carefully. Okay, have you finished answering the question? So don't worry. So if you do not know the answer, we'll analyze the case. The first one is about convincing lawyer. For the solicitor, so is his offer 30% discount to the client, and also 10% as commission. So we can use a very simple example. If the standard fee is $10,000, so he will give a 30% discount, so the client is only required to pay $7,000, and the commission is $700. So it means that the actual fee or the let fee received by the firm is only $6,300. So of course, so on the face of it, it looked like it's something so good for the solicitor. Of course, the reason why he makes such an offer is because he can get more business. He can attract more clients because other firm charge 10,000. He only charge 7,000. So of course, it's something quite attractive for the client. He can save 3,000. Also for the agent, he has the incentive to introduce his client to the lawyer. Because for the estate agent, he will be in contact with so many clients every day, so many prospective purchaser and also purchaser of the property. He knows so many people who have just bought property, who have just signed the provisional agreement, and of course they need the legal service. So it's not a very difficult job to introduce. So the client to the law firm, so he only have to spend very little time so that he can earn 7,700. Of course, it's also a side income for the estate agent. So the arrangement seems to be so good to everyone. But what is the objection? The problem is what will happen to the other law firm, right? For other law firm, if they insist on charging 10,000, they will lose a lot of income, right? They will lose a lot of business. Most of the business will go to the law firm because he is offering a discount. What will other law firm do? They will also do the same. Many law firms will follow suit. Many law firms will also give a 30% discount, 10% as commission to the estate agent. If you do not give any commission, no estate agent will introduce business to you, right? Of course, they will refer the business to the law firm which offer commission. Do you think the estate agent will care about the quality of the service of the solicitor? The answer is no. Just like so many middlemen. So no matter whether it's insurance, estate agent, usually they just care about the commission, right? So as long as someone gives them the commission, they will refer the business to those people, just like a tourist. The tourist guy will bring you to a shop. Why he bring you to that shop? Because the shop give him commission. Right? If a shop does not give any commission, the tourist guy will never bring you to that shop. Okay? Because he will get nothing. He will not get any commission. So you see, some tourist guys, they are so enthusiastic. Okay? So some people, they are so enthusiastic because they have the commission. Okay? So what happened? If all the or most of the law firm follow suit, if some law firm, some may be even more aggressive, he may give 40% discount or 15% as commission to the estate agent. So what will happen? At the end of the day, so you give more discount, for example, 40% discount. So you can you only charge 6,000, and you give say 15% to as commission. You give 900 to commission. So at the end of the day, so you only say the net income is only 5,100. So it's called undercutting, cutting through 割喉式so if all the law firm give discount and commission, what will happen? What will happen is that they will get less and less income. When the law firm can only get 5,000, 4,000, 3,000, what will happen? They don't care about the quality. Because the fee simply cannot cover a reasonable service. So many law firms, they will lower the price in order to attract more business, but the quality is terrible. At the end of the day, it will affect the reputation, the quality of service of many law firms. So at the end of the day, it will affect the reputation of the legal profession. Right? And also it will affect the interest of the citizen. So at the end of the day, so many citizens, they use the service of very substandard. So many, they go to many law firms which offer very substandard service. So it's the end result. Right? So there will be a lot of ethical problems because it will exert some pressure on other law firms. Many law firms, they are forced to follow suit. If they do not do so, they will lose most of the business. They cannot get any business. So the law firm, they don't care about the quality. So they just undercut the price. So it will adversely affect the quality of the service. How about number 2? Any problem? In terms of money, the agent will earn just a few hundred in this situation. But I think the time they use is very minimal. Usually, so they just pick up someone who has just purchased a property, and they just refer the client to the law firm. This is very different from persuading someone to buy a property. It's not the case. It's quite different. Number 2, what is the problem? What is the ethical problem? Conflict of interest. Why we have conflict of interest? The director will say, I only charge a very little, a very small fee. Why do you think there's still conflict of interest? I cannot get any interest. Anyone who can elaborate the meaning of conflict of interest in question 2? Double identity. Very good. So because there's a conflict in the role, because as for that gentleman, he has 2 different roles. On the first one, he's a director of the company. On the other hand, he's the barrister acting for the company. Any problem? Because there will be conflict of interest in the two different roles. Because as a director, what do you have to do? As a director, you have to supervise the performance of all the service provider, contractor. For example, if there's a decoration project, you have to supervise say the contractor. If there's if someone provide a translation service, you have to supervise his performance. You have to find out the best one. Maybe you have to use tender or some other means to find the best supplier. Even though after you have chosen the supplier, you still have to supervise his performance. If the performance is also good, you have to criticize him, you have to remind him, you have to tell him, you have to do so many things. But if you are at the same time you are the director. If you are also the barrister, how can you supervise yourself? Okay? You are in a conflicting position. Because as a director, you have to supervise the barrister, but if you are also the barrister, how can you supervise yourself? Okay? And also, for other directors, they may find it uncomfortable to supervise your performance because you are their colleagues, you are your fellow director. So they are not they find it difficult. They find it uncomfortable or embarrassing to supervise you. So it's the reason we say that it's something that may be potential conflict of interest. For potential, when we talk about conflict of interest, we do not say that there must be some actual harm which has been done. We only mean that potentially there will be conflict of interest. So potential conflict of interest is already enough. There's no need to prove there's actual conflict of interest. Right? For example, if you act for the buyer and seller, you are the estate agent, you can set a very reasonable price which is acceptable to both parties. But potentially, so you may be biased, right? In order to make the deal, you would sacrifice the interest of either the buyer or the seller. Conflict of interest sometimes is unavoidable. So as long as we have potential conflict of interest, it's already enough. There's no need to prove there's something bad has already been done. That's unnecessary. Okay, I think we can end the lecture now. So I think today's lesson is very long because this chapter has so many subtopics. And also in the examination, you can find so many possible questions for this chapter. In the next lesson, we will how about the volunteer? So I think it's still not so good. Can the director do LIP? LIP, I think he's practicing the barrister. He's a barrister in actual practice. So there's a lot LIP. So LIP means if a director, you mean the director? Okay, for company, of course, a company can ask its officer because company is not a natural person. Our company must be represented by someone, either by a lawyer or its own officer. If a company does not retain a lawyer, the company can ask one of his employee, officer like director or employee to represent the company. It's very common. Just like MTLC. So when I was working in MTLC, I know I will ask a staff to represent the company in some court case. So for example, in some small claim cases in small claim tribunal, I will ask an officer to represent the company. Hong Kong is a little bit different. Hong Kong allow an estate agent to act for both parties. But how he had to tell the other party. For example, if he is already acting for the seller, he has to tell the purchaser he's acting for the seller. He only has to disclose. But in Canada, it's not allowed. A lawyer is also the same. A lawyer, I think, for second-hand property, there must be separate representation. But for, say, a new property, 樓花, is still allowed. Because, so, we have to protect the interests of the developer and also those law firms. Those big law firms. Only big law firm will represent the client in some, say, some project, some development project. Usually the format is that so the for development project, so the developer will not pay any legal costs. So he will ask the lawyer to charge the purchaser. You see, illegal where there's ethical. I think there are two separate matters. Whether something is illegal or whether something is unethical. Unethical does not mean illegal. So for conflict of interest, usually, so there's a ethical problem. It may be professional misconduct. But usually it will not amount to criminal offense. There's something. I think I will do it in the next lesson. Sorry, we don't have enough time in this lesson, so I will do it in the next lesson. But some students ask me, so very briefly, this one, civil law and criminal are different. They serve two different purposes. The main point is for as we have mentioned before, criminal is the main purpose is punishment, and also deterrent. 懲罰同埋阻嚇 deterrent. If someone is punished, other people dare not commit the same offense. It's called punishment and also deterrent. Civil law is very different. Civil law is mainly aimed at compensation. Compensating the loss of the victim. Right? But of course, you have to refer to article. Please do some research. So of course, if you just type the difference between civil law and criminal law in Google, you can find many articles. So don't worry. Usually they will tell you so many things. Okay, any more question? Case one thing, it may be illegal. Whether you give, for example, so the law society in the past they have a scale. The scale fee. Scale fee means that the fee is determined by the law society. You cannot charge less. If you give discount, it's something. So it may be breaching the rule in the past. But now they don't have the scale fee. So all the lawyers, they can say negotiate with the client. So nowadays, if you want to, you may try. So you may give a call to the law firm. You can negotiate the fee with them. 好多都係可以傾嘅，咁打電話試下佢you may try. Okay, you may give a call to some law firm and you ask for the fee. You can negotiate with the lawyer. Also for the estate agent, whether he accept the commission, whether it's something ethical, it will be decided by, I think, by the estate agent authority. I'm not very sure. I'm not very sure whether they can accept this kind of referral fee. Of course, for civil servant, they are not allowed to do so. A civil servant can never accept advantage. So Chen Horman, so what's your question? You raise hand. Chen Horman, what's your question? So I think you can use the legal Google Scholar. You can use Google Scholar. You know, I think if you can find some article is already okay. Professional misconduct. I think we don't need to care whether it's a professional misconduct. But still, I think you only need to point out the ethical problem. Okay, thank you very much for attending the lecture. Also, thank you very much for attending the lecture and also all your participation. So thank you. Please, you know, it's already Thursday. So enjoy your weekend.